Web shipbroker, shipping education on the web. Hello and welcome to today's video on the legal rights and remedies of time charterers and bunker suppliers in a case involving a vessel that was time chartered and later withdrawn due to default in hire payments. The following was a question from the ICS May 2022 paper of Legal Principles. The vessel, A, was time chartered for 8 months. The vessel was withdrawn in the 6th month of the charter party, as the charterers defaulted in hire payments. The charterers are contesting wrongful withdrawal, as they claim that the required 48-hour notice was not given by the shipowners before such withdrawal. The shipowners have now concluded the sale of vessel A. It now transpires that bunkers were supplied to the vessel while it was time chartered, and the bunker receipt signed by the master of the vessel was addressed to charterers, owners, master. As we mentioned in the case scenario, the time charterers are contesting the wrongful withdrawal of the vessel by the shipowners, claiming that the required 48-hour notice was not given. It is also revealed that bunkers were supplied to the vessel while it was time chartered, and the bunker receipt was addressed to the charterers, owners, and master of the vessel. So, what are the legal rights and remedies of the time charterers and bunker suppliers in this situation? To answer this question, we need to consider several factors. First, we need to look at the terms of the charter party and the bunker supply contract. These contracts will likely specify the rights and obligations of the parties and any provisions related to withdrawal or termination of the contract. For example, the charter party may include a clause stating that the shipowners must give a certain amount of notice before withdrawing the vessel due to default in hire payments. Similarly, the bunker supply contract may include provisions related to payment and any remedies available to the supplier in case of default. In addition to the terms of the contracts, we also need to consider the applicable laws and jurisdiction. Different countries have different laws that may apply to the charter party and the bunker supply contract, and it is important to determine which laws will govern the rights and remedies of the parties. With these factors in mind, let's examine the specific rights and remedies of the time charterers and bunker suppliers in this case. If the bunkers were supplied before the withdrawal of the vessel, the time charterers may have a claim against the shipowners for breach of contract if the withdrawal was not justified or was not done in accordance with the terms of the charter party. For example, if the shipowners withdrew the vessel without giving the required notice or without a valid reason, the time charterers may have a claim for damages resulting from the breach. On the other hand, if the bunkers were supplied after the withdrawal of the vessel, the time charterers may not have a claim against the shipowners, as the charter party would have been terminated and the shipowners would not be responsible for any further obligations under the contract. However, the bunker suppliers may have a claim against the time charterers for payment, as the receipt signed by the master suggests that the bunkers were supplied to the time charterers. In this case, the bunker suppliers may be able to enforce their claim through legal action or by attaching a maritime lien to the vessel. It's important to seek legal advice in order to determine the specific rights and options available to the time charterers and bunker suppliers in this situation. An experienced maritime lawyer will be able to review the terms of the contracts and the applicable laws and advise on the best course of action. I hope you found this video informative. If you have any further questions or comments, please feel free to leave them in the comments section below. Thank you for watching. Subscribe to our channel.